Good afternoon, everybody, and welcome to our February 9th workshop on an entrepreneur's guide to intellectual property. My name is Len Lonzi. I'm the managing director for the Preccelerator program at Stubbs Alderson and Markleys. And today I have two of my colleagues, two partners from the firm who are experts in intellectual property and all matters concerned. And today they're going to give us a fairly high-level view of what intellectual property is, how it interacts with companies, and how you use it to protect yourself, protect your company. And I'm not going to get too far into the weeds on that. I'll let Heather and Kevin do that. But first, I'd like to introduce Heather Antoine, who is our partner and chair of the firm's trademark and brand protection practice, and co-chair of the Privacy and Data Security Practice Group at our firm. And our colleague, Kevin DeBray, who is the chair of the Intellectual Property and Technology Transactions Practice Group here at the firm. And I'm not going to go too far into their bios. That's their introduction today. And at this point, I'm going to turn it over to Heather and Kevin.
Hi
Thanks,
there.
Len.
Thanks, Len. So I think to get started, Kevin and I were just planning on kind of talking about the four major areas of intellectual property that companies and startups may have to tackle. And the first one that I was going to start with was actually copyrights, which may seem counterintuitive because most people probably think, well, copyrights, that protects music and art and photography, right? And the answer to that is yes, it does. But it also protects your software code and your marketing content and your website content. And so it's really valuable when you're a company and a startup in particular that you protect all of those assets. You know, we're probably going to speak heavier about other forms of IP during this presentation. So I do want to just take a minute here to really kind of focus on what can go wrong in the copyright world. Oh, Len, can we put the slide up? Awesome.
Voila.
So we do have this slide for everyone here today that goes through the four major types of intellectual property that Kevin and I are going to start by discussing. And, you know, we included the symbol here. So you'll see that under copyright, we said that, you know, it protects music, art, film, literary work, broadcasts. And it lasts, you know, if created after 1978, the life of the author plus 70 years. So what can go wrong is you can have issues relating to ownership. I would say that's the biggest issue that I see businesses have. So a founder starts a company before the company is even actually incorporated or formed, they're doing all of this work. So they're developing the software code, or they're developing the website content, or whatever it may be. They sketch out the logo, right? Which the logo is protected by trademark, but the sketch of it could also be protected by copyright. So they do all of this work, or they hire contractors to do all of this work, and there is no agreement in place. So then the company is actually formed. We don't have an agreement that transfers ownership of the copyright from the founder into the entity. And you have a situation where the entity doesn't own the copyright to anything. And that can definitely be one of the biggest problems moving forward. As far as contractors are concerned, you always want to keep in mind work for hire agreements should be in writing. People often think, you know, well, it's assumed, and make no assumptions. You should have things in writing, make sure that's all your, you know, I's are dotted and T's are crossed. And, you know, and the last thing that I want to mention that I think is really important in the copyright world is to track what open source software is used, track it early and track it often. Because when you're moving really fast, you're, you know, and which you are as a business usually, you start using a lot of open source software. And then when it comes time to sell your business, someone looks at you and says, do you have a list of all of the software you've used? And you stare at them and say, I'm not sure. And so it's better to track it early and make sure that you're tracking all of the copyright licenses you've used in that sense, than have to deal with it later. Kevin, is there anything you want to add to that?
No, I think you did a great job.
Okay.
Oh, maybe you can talk about, is it necessary to register a copyright?
Oh, that's a good question. So from the minute something is created, you actually have copyright protection. So a lot of people think based on that you don't have to register, but it's always advisable to register your copyright with the Copyright Office, because otherwise what ends up happening is if someone infringes on your copyright, you won't be entitled to the statutory damages, which is really what enables you to go after people in these cases. It's up to $150,000 per infringement. And so you want to make sure that you register it, even though you may have copyright protection in common law the minute something is created.
Great, thanks, Heather. I'm going to talk about patents. And as Heather mentioned, that there are 4 principal areas of US intellectual property protection that we're going to go over: copyrights, patents, trademarks, and trade secrets. And patents cover inventions. What are inventions? Well, inventions could be products like articles of manufacture, chemical compounds, processes, improvements, and well, it might be useful to have an example of an invention. So let's make something up. Let's say that you've invented a face mask that is 100% effective in blocking COVID-19. Should I put this on for, no, okay, for demonstration purposes. But let's say it's 100% effective in blocking the virus. And what does that protect? Well, that could be an invention, and it might meet the 3 requirements of patentability, which are novelty, never been invented before, useful, it's definitely useful, and non-obvious. It's not obvious. The invention is not obvious based upon what has been invented before. So in that case, what does let's say you're able to get a patent on that invention. What are you able to do? Well, actually, you're not able to do anything other than exclude others from making, using, selling, offering for sale, and importing the invention. Actually, the invention that's described in and claimed in a patent, an issued patent. And so what that means is, and I'll tell you why I'm drawing that distinction, because you can go ahead and make this thing and potentially infringe somebody else's patent that is also covers this in a different way. Perhaps somebody has a design patent on this, the design of how it looks. And so you could make this, and maybe there's a coating on it that makes it effective in blocking the virus, but it still has the same design. You could infringe their design patent and therefore not be able to make, use, sell, offer for sale, and import your patented product. So that's why I say a patent enables you to prevent others from making, using, selling, offering for sale, and importing your invention, the face mask with the 100% COVID-proof coating, but it doesn't necessarily guarantee that you'll be able to do the same to make it. A patent, as the chart says, lasts for 20 years. Why do we have 14 up there? And I should mention it's 20 years from the date of filing the patent application. So the patent application goes through the process at the US Patent and Trademark Office, issues as a patent, hopefully. You have 20 years from the date it was initially filed. 14 years covers design patents. There are 3 types of patents that are available under US patent law: design patents, plant patents that are for asexually reproduced plants, like genetically engineered plants, and utility patents. I think you need to put your mic on mute, who's ever talking.
Tell her yes. Online it says 1,500.
Lana, we able to meet that? Design patents only last for 14 years. And that's why we have 14 to 20 years there. The last thing I'll mention is, in contrast to what Heather said about copyrights, that even though you have copyright protection, it is beneficial to register a copyright. Under patent law, you don't have patent rights until and unless you have an issued patent. So you actually need to file a patent application in order to get the protection that a patent offers. And is there anything I left out, Heather, that you could think of?
I think you got it. I think you got it all.
Okay.
I guess the one question I would have is, you
Yeah.
mentioned that an invention can be covered by multiple different patents. So how do you avoid running into someone else's patent?
Right. So one way you can't avoid it 100%. There's always going to be a risk that you might step in a snake pit, so to speak, of somebody else's patent or patents. But you can get some visibility into the risk of that by doing a freedom to operate search. It's a search of issued patents and pending patent applications that are in the same field as your invention. And that will give you an idea of how close or far away your invention is from what is out there. The benefit, obviously, is it gives you a degree of a sense of what the risk is of an infringement. The downside of it is that patent applications are maintained in secrecy in the U.S. Patent and Trademark Office for 18 months. So whatever search you do, you're only seeing things that were filed in the patent office 18 months ago. And so there's a black hole as to sort of some application that may be pending out there that may issue as a patent eventually that you could infringe that you wouldn't know about.
Okay.
So with that, why don't we move on to trademarks?
Sure. So the next type of IP that I want to talk about is, prejudicially here, my favorite type of IP, which is trademarks, hence being the chair of the trademark department. But trademarks to me are the most fun you can have in the IP world, and they protect your brand. And so it protects your brand in as many ways as you can possibly think of. And a lot of the times when we think of trademarks, we think of the very obvious one. So the name of the company, the logo of the company, if the company has a slogan, those would be the major points that you want to protect under trademark law. But trademarks actually go further, and this may not come up for most people, but I always find it very relevant to just explain. It's really anything that someone hears, smells, sees, and thinks of your brand. And yes, it includes scents. So Play-Doh, for example, has trademarked the smell of Play-Doh, which many of you can probably think of right now. That's how distinctive it is. And, the MGM lion going roar, terrible recreation here, but that's also an example of a sound trademark. Color trademarks would be UPS brown, as much as I think it's horrible, and Tiffany blue and Pepto-Bismol pink. So anything that when you see it, you think to yourself, that's X company, that's how you know something can be protected by trademark. That's the value of a brand. And as you know, when you're getting started, that value is probably much, much less because there's no goodwill, right? So you haven't done anything at that point to really develop the fact that when someone sees Tiffany blue, they know it's Tiffany blue, right? That value gets developed over time, but it's also really important that you start protecting it as early as possible, because what you don't want to have happen is one of two things. You don't want to end up in a position where, let's say we forgot to run a search for a name, and and the name, it turns out, is being used, or something similar is being used by another registered trademark owner. So now, as you're gaining popularity and as you're starting to move along in your company, all of a sudden you receive a cease and desist letter. That's, scenario one. Or two, we try to actually then file a registration once you have funding in, which is what a lot of people wait for. Let me get some funding in to file these trademarks. And then we go and we run a search and we discover this other company, and I end up telling you, which happens all the time, you need to pick a new name, because you're probably not going to get this trademark registration. And that's a really hard conversation to have 2 years or 3 years into a company. It's much easier to have that conversation as you're getting started. So I always say trademarks are really important, and I think they're one of the most important things you can do. Len, can we mute?
I don't know who's doing that. I can't see anybody making that noise. I'm sorry.
That's okay. So that's, the two situations that you want to keep a lookout for on the trademark side. And I'll go into a little bit later about how to pick a trademark, but I really want to emphasize the value of IP here and the value of your trademark portfolio, because often when it comes time for sale, that is a very valuable piece of the company. If you're selling Nike, which let's hope we all become Nike at some point, but if you're selling Nike, the value of that logo is massive. You know that logo anywhere. And so that's something to keep in mind. Kevin, anything you want to add on that?
Yeah, if you have a trademark, you don't really have to register it, do you?
Yeah, so that is another one of those interesting situations. So if you have a trademark, you do have common law trademark rights, but the same as it is with copyright, although in a different, not to get too legally technical here, but you have greater rights when you've registered something and you have more of an ability to enforce your mark. So let's say you have a common law mark and you've only been selling services that you can track in California, Nevada, and Utah. And then someone else starts selling, those same services using a similar name in Connecticut. If you only had common law rights, you don't have a presumption of federal and nationwide protection. And that ends up being a really big problem. So you always want to register because you give yourself a greater platform of protection to go off of.
Yeah, as an IP nerd, I love the story of the Amazon trademark, which is there was a Amazon bookstore, feminist bookstore in Minneapolis that started, I think, in 1977, well before the internet and before Amazon got its registered trademark for Amazon for selling books over the internet. And when Amazon came out in 96 with its registered trademark, the Amazon bookstore came knocking, and Amazon.com ended up taking a license because the feminist bookstore had prior use within the geographic area of Minneapolis where they had been using it since 1977. I'm going to talk.
Before we go on, just a quick question, because I'm looking at this chart and other people might be looking at it also. What is the SM and the R with the circle around it?
That's a great question, Len. So before your trademark is registered with the USPTO, you are allowed to indicate that you have common law trademark rights by either using TM, so trademark, or another thing that you'll see people use is if you're providing services rather than goods, people use SM to indicate a service mark. And that's for when you haven't registered, but you want to tell the world this is our trademark. So we have common law rights.
Thank you.
Mm-hmm.
So I'm going to talk about.
I think we
go
have
ahead. Yeah.
Sorry, just a quick question. Just a little more clarification, Heather, on the trademark. And Kevin, great example with the Amazon. So when you trademark a word, a symbol, you're saying that protects you more on the national level, more federal level, I think you said, versus just, not trademarking a symbol and proving that, I started my business in 1970, you started in 1997, does that make sense? It seems easy. You could prove that, like Kevin's Amazon, you could prove that you've used that name prior to someone else pretty easily. So I'm just wondering what the trademark, just clarification, if that protects you more on the national level, I think I heard, versus local. Is that kind of the...
Yeah, this could actually be probably an hour conversation in and of itself, but kind of a high level view of it is what you have when you have a federal registration is a presumption of federal protection, right? So as long as you've had interstate commerce and you can prove that you've used interstate, then people can search for you on the USPTO website and you're registered, right? So then no one can use, or no one should use, a similar name. And when the USPTO trademark examiners run searches, you will come up in their search. So you will also be cited potentially against other people who are trying to use a similar name. So there's a lot of benefit that comes from registration. Whereas if you're a common law mark, let's say you haven't registered, but you've been using it and you can prove you've been using it, and the trademark examiner won't know you exist, right? So that's problem number one, because if someone files an application that's potentially conflicting with yours, they're not going to search the internet to look for you. That's not what they do. They only search their database. So they search their database, you don't come up, they've now cleared that other application for publication, for example. Now you actually have to file to oppose that application, and you may not even know it exists. So it's just so much harder. There's geographic limitations that come with common law, which is what Kevin and I mentioned. There's also issues of not being potentially found. There's issues that you then have to do. What's a penny wise, pound foolish? You may save the $1,500 to file the application, but then you're now going to spend $30,000 opposing someone's application and proving that you were there first. So there's a lot of issues that come with not registering.
That makes sense. Thank you.
Yeah.
Oh, but Heather, LegalZoom only charges $199. No, we'll get into that later.
That's a different one. That's a different conversation.
I'm going to talk about trade secrets. And so what is a trade secret? A trade secret protects information that is not generally known to the public. So I'm going to use my face mask example again. Let's assume that there's that coating that protects the face mask from the virus penetrating and getting to the user. And that chemical coating is a formulation that is a secret, kind of like the Coca-Cola formula.
Class, right.
And therefore, that would be protected by a trade secret so long as the trade secret is kept secret. What do you need to do in order to protect trade secrets? You need to take reasonable steps to maintain the secrecy of the trade secret. Now, does that mean that all confidential information is a trade secret? No, only confidential information that provides the owner an advantage, like an economic advantage or a competitive advantage, as a result of the information being maintained in secrecy. And so what are some examples of taking reasonable steps to maintain secrecy of a trade secret? Well, it could be it's an NDA, a non-disclosure agreement, entering into an agreement with somebody to say, hey, this is confidential information. You can't use it unless you, for purposes that we are exchanging information for, and you can't share it with anybody else. Another example of a trade secret might be by limiting the access to information within your company to certain information. Other examples of trade secrets besides like chemical formulations or coatings, for example, would be processes, manufacturing processes, specifications, financial information, business plans, source code for computer software. And the important thing to know is about trade secrets is, what does it protect? It protects, as the chart says, against misappropriation, basically theft. And so it, unlike patents, where you can infringe a patent without even knowing about it, just by having it be there and by happening to step into the snake pit of the patent, in a trade secret, you are violating the trade secret rights by taking it without authorization or using it without authorization. Very different. And what that means, they're kind of two opposite sides of the same coin, but they protect different things in different ways. And you could, if you happen to independently invent or develop somebody else's trade secret, you're not going to be liable for trade secret theft because you didn't steal it. So I will stop there and see if, Heather, did I leave anything out on trade secrets?
I guess a good question is, can you have something protected by trade secret and patent at the same time?
Excellent question. And I wish I could say that we had prepared that one in advance, but we didn't.
Sorry.
No, that's a great question. I'm going to go back to my example of the face mask. And great thing about this example is that it, this invention, and so for those of you who joined late, my example is a face mask that has a coating on it that is 100% effective of blocking the virus from entering through the face mask and getting to the wearer. Hypothetical, of course. And it could be protected by patents because it's an invention. And if it meets the requirements of patentability, novelty, non-obviousness, and usefulness, it might be patentable. The coating could be protected by a trade secret if the formulation of the coating is not generally available to the public. The artist renderings of the appearance, let's say, of the face mask, those drawings, those sketches could be protectable by copyright. And if there's a trademark on it, this one says KN95, that's not a trademark, but if it's, let's say, Vax Me Now is the trademark, you could have trademark protection on the face mask. So in fact, products could contain one or several different forms of intellectual property protection.
Excellent. Thank you. So we have some questions that we all discussed earlier, and maybe now's a good time to dive into those. So, Kevin, how should an entrepreneur respond when the potential investor asks them if they have any intellectual property?
Yeah, that's a question that I get a lot from startup entrepreneurs because investors do ask that question. And the answer is, obviously, it depends on the company, it depends on the business. But in most cases, startup companies, no matter what stage they're in, have some intellectual property. They may not have issued patents. In fact, a fun fact is that Broadcom Corporation, that down in Irvine that makes semiconductors, had absolutely no issued patents by the time it went public. So you don't have to have an issued patent or even a pending patent application in order to have IP. You have IP just by having trade secrets or copyrightable material that you have prepared. Could be sketches, design drawings, business plan, financial projections. So a company could have lots of IP. It may not be necessarily registered. I think a good response to a question like that from an investor is, yes, we have IP, and we, as a startup on a very limited budget, are taking steps to be, I call it IP aware of the intellectual property that we have, and taking steps not to lose it, to preserve it, and keep track of it so that when we do have a budget after you invest in our company, we will be able to take active measures to make informed decisions about how to best protect it, either by preparing patent applications or trademark registration applications, or even registering our copyrights.
And maybe just a quick follow-up to that, because it pertains to the same issue. Many entrepreneurs or founders will come to the table to investors and say, hey, I'd love to tell you about what I'm doing, but I want you to sign an NDA. How do you respond to that?
Yeah, that's a rookie mistake, because most investors will not sign NDAs. So I don't recommend asking the investor to do so. But this applies to, your question applies to whether the potential recipient of the information is an investor or potential business partner or possible or prospective contractor or prospective employee, any third party. Number one, and this is just basic, but I gotta say it, trustworthiness. Don't disclose information, sensitive information, to somebody who isn't a trusted recipient of that information. So you'll want to vet that person. Then don't feel compelled to disclose everything. Just be selective in what you disclose. When people say, well, I got to tell them about my proprietary technology, I say, well, maybe you can talk about the what, but not the how. Talk about what it does, what benefits it provides, but not how it does it, not how you implement it. Hold back the secret sauce. Be very mindful of what you're disclosing and what you're not disclosing. And then very importantly, and this is something that very few people do, but I'm going to let you in on this, is keep track of what you disclose and to whom and under what circumstances, because 6 months, a year down the road, when something happens, if something happens, you're not going to remember it. And you're going to want to go back to your records and say, oh, I disclosed that to this company, and now that element is in their product. You'll want to use that as perhaps evaluating, or give that to an attorney to evaluate whether you have a claim against that company.
Great answer. Thanks, Kevin. Heather, what should an entrepreneur consider when choosing a name for their venture?
So this is probably the most common question that I get asked or brought to. So, what we do when someone says we have a name that we want to use or a logo that we want to use, we then go through a process of running a search. And in that search, we try to determine whether there's other companies out there that are using similar names. The odds are, the more descriptive your name is, the more likely there is going to be other companies that are using the name. And so when you're choosing a name for your company, there is a spectrum that you can fall into. And in the not protectable at all arena would be a generic name. So bicycle for bikes is going to be a problem. Even if you spell it differently, even if you add a semicolon where, the I is supposed to be, it's still bicycle. So that would be a no-no. You will not get any trademark protection for that. One level up from there is going to be a descriptive trademark. And descriptive trademarks would be, and this is kind of a bad example because of where they are now, but American Airlines, that is an example of a descriptive trademark. Can a descriptive trademark get stronger over time? Yes, but it's not something you ever want to start with. You never want to be creamy for yogurt. That's going to put you in a weak position from the get-go. And if you have a weak trademark, it's very hard to enforce your rights against other people. The next level up from descriptive, which is really where I tell people you want to at least be in this area, is going to be a suggestive trademark. Suggestive trademarks are suggestive for the goods that are being provided. So think of glance-a-day for calendars or copper tone for sunscreen. If you see the name, you kind of have an idea of what it is, but it may not be an immediate thought. You have to kind of go, oh, that makes sense. That's a suggested mark. Now, the sweet spot is going to be in the next two levels. And the next two levels is what I would say every every entrepreneur and every company should strive for. The second level, the next level up is arbitrary. And arbitrary trademarks have no relation to what you're providing. So think Apple for computers, think Dove for soap. Oftentimes people come to me and say, but we have to have the mark kind of tell you what the services are. And I always say to people, no, you don't. And in fact, the strongest trademarks, the ones that you will identify without fail, Uber, for example, Uber could have called themselves, we love rideshare, but they would have had no protection. They're Uber, and everybody knows that name, right? Lyft is actually an example of something that's going to be a weaker trademark in there. So you want to be in the Apple for computers. The Jaguar for cars is probably in between suggestive and arbitrary, but that's still a really good trademark. And then the highest level of protection you can have is from a fanciful mark, and that just means you made it up. So Kodak, Exxon, Polaroid, Aspirin, those are all made up names. Escalator, they're made up names, and you would recognize those anywhere. The one problem with having a trademark that's super strong and becomes super common like that is that you run the risk, and this is a really, really good problem to have, that people start using your word to describe everyone's products rather than just your products. So now when people say, hey, let's grab an Uber, but they're actually calling it Lyft, that's a potential problem because you're no longer identifying the source, the company, you're identifying kind of everyone in general. But that's a really wonderful problem to have because it means you have made quite an impact on society at that point. So I tell people not to worry about it. There's always ways to protect that. Kodak actually did a really good example of this where, or no, it was Xerox. Xerox had an entire campaign in the 90s where they put out leaflets and magazines and press everywhere that said, you know, please don't use Xerox as a substitute for photocopy. So the stronger, the more unique name, the better it's going to be to set you up for strength of your IP on sale, and then also to make sure no one else is using it.
Heather, I'm going to ask a question. We'll get to you next, Ryan. And that is, so what does it take to infringe somebody's trademark or to have somebody infringe my trademark?
So that's a really good question. There's actually there's two series of factors. There's the DuPont factors and the Sleek-Krat factors, which I will not get into here. But generally speaking, there's about 10 elements that you want to look at when you're considering whether someone is infringing on your mark. And it's going to be, you know, substantial similarity. So would you, the normal consumer, be confused when that the services or the goods being provided are coming from the same place? So, you know, are Nike and NYKES, Nikes, is that a potential problem? Yes, that's a potential problem. So it's going to be similarity in sight, sound, connotation, like commercial impression is also something it could be too similar with. So if you start potentially selling computers and call them Pear, you may have a problem. Apple may come after you, even though it doesn't look the same or sound the same, because it has a similar commercial impression. So there's a number of factors that go into it, but the easiest one to think of is, would this cause confusion?
Ryan, did you have a question?
Yeah, and it was honestly on these lines of kind of, let's say there's like a car company that wanted to be called Apple Cars, or a construction company that wanted to use Tiffany Blue or something like that. How does that work if they're not necessarily correlated?
Yeah, so if you're not a famous mark and something is not correlated, then you can use the name. So let's say you are not Tiffany, but you just have a color that you use that's orange, and maybe you did even manage to get that orange registered or the name registered. but someone is going to use it for something completely different. You don't have rights to everything by registering your name or by registering your logo. You only have rights to related goods and services. However, there's an exception for famous marks, and the standard for being a famous mark is actually pretty high. It's not, there's lots of case law out there that goes into marks that you would have thought were famous that were not. But if you do have a famous mark, then potentially there are other avenues that mark can go after you for. And so it maybe wouldn't be likelihood of confusion, because let's say you're selling cars and the other person is selling coffee. Maybe there's no confusion there, but maybe there's dilution, which is what the other standard would be, that you're, by you using that mark, because we're famous, you're watering down the value of our mark. So that's another way that they could come after you.
That was great. Thank you very much.
Kevin, did you have anything to add? Otherwise,
no.
I'm going to throw the next question then towards you.
Okay,
So,
I'm ready.
Why should you patent your idea? What's the value of doing a patent in the first place?
Well, and that's kind of a question that I get a lot from, another question I get a lot from entrepreneurs, especially first-time entrepreneurs, is, should I patent my invention? And, my response is that, obtaining a patent does not guarantee business success. So I think it's important to really understand what one's goal or goals are in filing for patent protection and trying to get a patent. And there are a lot of goals, potential goals, some better than others. Some goals are like, I want to, I have an invention that can be easily reverse engineered as soon as I put it out on the market. And so I don't have trade secret protection at that point. I need to have some barrier against my competitors. Or this is an area that I see industry moving into, and 2, 3, 4 years from now, there's going to be a lot of people doing this thing, and I want to be the first one to lock down this space and potentially prevent them from doing so. Another potential goal is, I think it looks good for investors. And that's not one that I think is a great reason to get a patent or try to get a patent, because patents are expensive. They easily, just filing the patent application is $15,000 plus, and then it can cost around up to $25,000 over the course of time until it's issued, if it's issued, and that's just in the US. And then there's foreign protection. And then that's just one patent. And you have to remember that, I always say that the value of a patent is your ability to enforce it. And so the patent wars are really fought with portfolios of patents. So now what we're talking about is not just one patent, but it's multiple patents. So you have to budget for this. And an entrepreneur who says, well, I just have one invention, I'm just worried about this one, concerned about this one product or invention that I want to file a patent application for. Something that I have learned over the years as a technology attorney is innovators continue to innovate. Your invention that you have today that you're thinking about patenting is not going to be your last invention. So you have to kind of plan ahead for how you're going to budget for the innovations that you have in the future, whether you're going to protect them all, how you're going to be selective in protecting them, or filing patent applications for them, and then build that sort of planning process into the DNA of your company. So patent protection or IP protection is not just a check the box, yeah, I did that, now I could forget about it for a while, but it's part of the business planning process that you're thinking about and you're aware of, about how that IP protection aligns with the business objectives that you have as a company going forward with products that you're bringing out into the market.
Okay, we have a question from Anastasio, and basically it goes to, if you do file a patent, you have to make your invention public. And once your invention is public, you never know what a bigger company might do in taking that IP. Is that a good position to be in or not? And, you know, how do you fight big tech companies that may have infringed on something that you own?
Right. Anastasio, that's an excellent question, because that's one of the factors one should consider in deciding whether or not to file a patent application. Are you going to be revealing information about your invention that you can maintain as a trade secret? Or maybe you can just file a patent application and describe your invention without revealing some elements that you can maintain as a trade secret. So it is important to keep that in mind, what you need to disclose in a patent application, and whether it makes sense to do so, or just keep the whole thing protected as a trade secret, so that, as I mentioned earlier, 18 months after you file that patent application, it's going to be publicly available and competitors can review it and see how you implement your product or your process. How you go about, if you decide, let's say you're going to put your product out on the marketplace and somebody could take it apart and see how it's built, so you might as well file a patent application and try to protect it under patent law. How do you stop a big competitor from infringing it? Just reverse engineering, or seeing your patent and replicating it themselves. Well, yes, you would have to bring a legal action against them for patent infringement. And how do you do that as a little company without capital? It's very tough, but you don't have to do it right away. You can monitor the infringer. You could see what kind of damages that you could be accumulating. There are attorneys out there who will take cases like that on contingency. If the amount of damages are high enough, they might be interested in taking that case. There are companies out there that finance patent infringement litigation, that for in exchange for a part of the judgment or settlement that's realized. So there are ways to finance enforcement of a patent if it's being infringed. So I wouldn't necessarily discount patents just because you're not going to be able to afford to enforce it. And then the other thing I'll mention is, you have to be planning for success. Those of you who are entrepreneurs aren't doing this because you're just gonna, you have nothing else better to do with your time. You're doing it because your ventures, because you believe that you're going to be successful, and your successful product or service is going to have an impact on the way we live and work and play. And with that in mind, when you are successful and you do have the capital, you would be able to enforce the intellectual property that has been violated.
Great answer. So this, the next question is something I run across a lot. Why do I need an attorney to file a patent or a copyright when I can do it with an online service, or I can do it myself? What are some of the pitfalls there? And I'll let Heather start that.
So from a trademark perspective, I'll start with trademarks. I always say that the trademark system is deceptively simple. It looks like something you can do yourself. And if you spend enough time, you may be able to figure out how to do it yourself. I don't think that's the best use of anyone's time, but if you spent enough time, you may be able to. And then there's companies like LegalZoom and Trademarkia that'll do it for a fraction of the price of a law firm. So why hire an attorney, right? Why spend that money? The value that you get from hiring an attorney is not the actual filing, it's what goes into the filing. So what I'm going to do if I'm hired to work with you on trademark is, one, counsel you on how to pick the name. Two, when we run a knockout search, which is just a high level, search to see if there's any red flags out there that are going to knock you out, we actually go through and tell you what that knockout search means. If you're filing it yourself, the odds are you don't know how to run a knockout search. If you use LegalZoom or Trademarkia, they will give you a stack of results and not tell you what any of it means, and just ask you if you want to proceed to the filing. That is one of the most important parts of a trademark application, is actually the knockout search and the counseling that goes around that. The second most important part is picking your descriptions. There is an art to picking trademark descriptions. Most people think they'll just throw everything in there. They'll prove use for one of them. Let's say you're opening up a coffee shop, and in that coffee shop, to start, you're only going to be selling coffee and tea. But what you've done is file the trademark yourself. You didn't know that what you weren't supposed to do was also throw in water, and retail store services and all of these other things that maybe you're not providing because you think at some point you're going to provide them. Or, you know, there's a misunderstanding of how those descriptions are brought together. And you may get through registration, because what you'll do is you'll prove that you're selling coffee, and so then you're going to get coffee and tea and everything that goes in that class. What happens 4 years down the line is someone like me, because I've done this to many people and it is what it is, goes through your application and sees what you did to start with. And now I file a petition to cancel your registration based on fraud. And you can have your mark. I know, Kevin, don't shake your head.
You're so aggressive, Heather.
I am aggressive when I have to be. You can have your mark canceled based on, you know, an error that you didn't know was fraudulent. You didn't know how to file it, but because the descriptions are so tricky, that's where the value of hiring an attorney comes in. So I always say, yes, you should hire an attorney. I understand there's a cost associated with it. But I think there's value in it. I will make one note about copyrights. So copyrights are interesting. Copyrights, when it comes to source code, I think is tricky. When it comes to music, I don't know if anyone's in that, you know, in that space. It's probably not that applicable here, or art. The copyright system is actually built for creators, so it's much simpler than the trademark system, much more easy to navigate. And so if you, let's say you are an artist and you want to file your music for copyright protection, I wouldn't say it's the end of the world to do it yourself. It's probably something you can figure out yourself, and frankly, for some people that are friends who are artists, you know, I just teach them how to do one and then they do the rest. I would never do that for a trademark. It's just a different world.
So I'll make 2 points really quick. The first is going back to what I said earlier, the value of a patent, and I think trademark, is your ability to enforce it. Mm-hmm. If you go to enforce your patent, let's say you're that big successful company years from now, after you file that application, you get that issued patent, now you go to enforce it, and it's a patent application that you prepared yourself, never did it before, or maybe you've done it before once or twice, and it's just deficient. It's deficient in a number of ways. And if you've ever read a patent, an issued patent, it's like a different language. It's very arcane, and the first defense that an infringer will assert against a patent holder is invalidity. The patent's invalid. Well, how can a patent that was issued by the US Patent and Trademark Office be invalid? Because sometimes the patent examiners make mistakes. An issued patent has a presumption of validity. It's not a guarantee of validity. And so when you bring that patent, what you're doing is you're giving the other side the ability to basically tear it apart. And if it wasn't prepared by an expert in patent law, patent lawyer who knows that technology, then you are going to be vulnerable to attack. And you may end up not just losing the case, but also losing your patent. The other thing I'll mention really quickly is oftentimes what happens when entrepreneurs prepare these applications themselves is they file it, then they get a response from the US Patent and Trademark Office, trademark application or patent application. They don't know what to do. Then they come to us and they say, can you help save my application? And usually it is so defective from the get-go that we say, no, we're going to have to refile. Now you've lost time in terms of priority and money. So I don't think it's a great idea to do it yourself.
There is a question for entrepreneurs. How do they budget for legal services like this? How, you know, is it something that you call a firm, you call Kevin or you call Heather and say, I'm thinking about doing this. Can you ballpark about how much time and money this is going to cost for me to, so I know in my, you know, as I prepare my financials and do my modeling, I know where these expenses are going to come?
Heather, you want to take that, or would you like me to?
You can, yeah, you can start.
Okay, I think, yeah, that's a fine way to approach it. Is the way I do it is I like to understand the company, the business, what their plans are, and then I will come up with a sort of a list of legal needs that they have ranked in order of priority, what they have to do immediate, near term, medium term, and then put together some numbers. I've done this long enough where I know what things cost. I'm usually able to estimate costs based for work that we do. I can't predict what a negotiation is going to cost, but you know, for a financing, let's say, I can ballpark that. So yeah, we could put together like a legal budget of what their needs will end up costing.
Now, I'll add on to that, which is attorneys, like in general, and especially any attorney you're going to find at our firm, will not only make that budget, but like Kevin is saying, will tell you, we understand everyone is on a budget. And so if the amount that we think you need in legal is 10 grand, but you only have 5 grand budgeted, or if it's 50 grand, but you only have 20 grand budgeted, we will make it so that we give you the risk of not doing these items, but also tell you, you probably need to do these items first. And that's something we all work together to do, because we get it. No one has unlimited funds, especially when you're starting out. And so it is something that, you know, we'll work with the client on.
Super. So let's
let me just jump in one more,
yes,
one more thing, and that is, it's important for entrepreneurs to know how to work with their professional service providers, whether they are attorneys or accountants. And that means that, you know, time is valuable. And so the more homework you can do for, let's say, the attorney to provide him or her the information they need in order to do the work, the better. If you're going to say, yeah, I have this idea, I want to file a patent application for it, I've written a few sentences, and that attorney has to basically interview you to drag that information out of you, that's going to be expensive. However, if you come prepared with a full-blown, let's say, invention disclosure that describes the invention in great detail, where the attorney doesn't have to spend as much time pulling that information out of you, it's going to be more efficient and more cost-effective.
Thanks. That's great insight, Kevin. Switching gears, here's a great question, and I get this from folks because it goes to privacy and terms of use and writing those policies. Can I just copy a competitor's and use them? And why are these documents important? And I think this is Heather's question.
Yeah, so this is a really great question. It's a question we get asked often. So why are we talking about it here? Because the data that you collect from consumers, from your employees, from whoever, is intellectual property. It is property you can't touch, right? So we're talking about it today because it does fall under that blanket. And so what you don't want to do, and the reason you don't want to do this is going to be very obvious when I explain it to you, but when you have a privacy policy, for example, what you're telling consumers is what you do with data, how you collect it, how you store it, what third parties have access to it. And it's very specific. It's almost like a fingerprint to you. And if you just copy a competitor's privacy policy, what you're now telling the world is how they collect their data, how they store their data, what third parties have access to their data. And so you're telling consumers that are now agreeing to your privacy policy a completely wrong set of facts. And that's actually going to create more liability than you would have had if you didn't have a privacy policy at all, which is a bad idea, by the way, because you can be fined for that. So this is another one of those situations where, yes, we're going to obviously tell you you need a lawyer, or you need to actually, do the work to make sure that it is made for you, tailored for you. The other thing is on the terms of use side, or maybe I'll have Kevin, do you want to talk about the terms of use side for this and why not copy? No. Okay.
I could.
Okay.
I mean,
so on the terms of use side, if you just copy a competitor's, and I want you guys to know the things that I've seen when people have asked me to fix their policies years down the road. I have asked people, why is your governing law in New York for companies that are in LA? And they go, oh, we copied the clause and we thought there was some benefit to having governing law in New York. Well, there isn't. If you're here in LA, there may be benefits to having it in other places, but you want to be careful that you're not now tying yourself to something which you're saying to all of the consumers, if you want to sue me, you now get to sue me in New York. And let's say there's a New York consumer out there who has an issue with your product or service, you're screwed, because now you have to defend yourself in New York, which is going to be so much more expensive than doing it, and probably less efficient than doing it in your home state or with the state of law that you choose. You can also have situations where you're telling people that you have registered a DMCA copyright agent, but you didn't register. So you actually don't get any of the protections of safe harbor that way. And so there's so many problems that can come with saying, our competitor does it this way, let's just copy and put it on. And that's the same issue you can have with trademark descriptions, which a lot of people do, which is, our competitor uses these descriptions, let's use them. That's never something you want to do on either case.
Right. And I'll add to that in that I think it's a good checklist. You can use a competitor's terms of use as a checklist for things that maybe you want to make sure you've thought about in terms of how your website or how your app is going to operate. But I agree 100% with Heather. You don't want to sort of cut and paste. You may want to say to the attorney who's preparing it that, oh, and I noticed that our competitor is doing this sort of thing, and we may be doing that sort of thing too. So you want to address that. The other thing I want to mention is any relatively smart person could read a terms of use or privacy policy and understand it, and not a big deal to say, yeah, well, I can understand what that says, and so why not use it for myself? What people who are not routinely working in this space don't realize is what's not there, the white space. What's missing? What's missing that should be there? And that's when an attorney who specializes in this area is going to be able to provide for you, is holistically looking at your business practices, the way you collect, use, store, and share information, and provide a tailored document that addresses those points. And that may include things that are not in your competitor's terms of use or privacy policy.
Can I give one more example that actually happened yesterday of something that's top of mind? It's to me, this is like one of those issues that I think is very dangerous. So someone drafted a privacy policy, they sent it to us to actually edit. And I asked them, you have an entire section in here about the California Consumer Privacy Act. Do you have to comply with the California Consumer Privacy Act? And they said, well, we're a business in California. And I said, okay, is that the analysis that went into it? And the answer was yes. It turns out they do not have to comply with the California Consumer Privacy Act. So what they've done by putting that section in their privacy policy is actually give people rights that they wouldn't otherwise have had, because they've now held it out as a right that these people get, the right to deletion, the right to access, the right to opt out. And they also did that without doing any of the back end compliance work that you need for the CCPA. So they didn't do the data mapping. They don't have vendor agreements. They don't have any of the back end because they didn't know that was something they had to do. So it looks innocuous enough to say, oh, we're in California, let's put this section in, or let's put this section in on the GDPR for the EU, right? But you could actually be hurting yourself by not thinking that through and working with someone to realize whether you actually do have to comply or not.
And on the theme of how to effectively work with a lawyer cost effectively, some people think that, well, if I prepare these documents and send them to Heather or Kevin, all they need to do is look at them and make a few little edits, and it will be a lot less expensive for me. The answer is no, because that actually takes us a lot longer at our hourly rates to do that work than to understand what the business is and then use our vetted state-of-the-art templates that we have created time and time again and modify and tailor those for the client. That's how we cost effectively are able to provide good legal services to startup companies at reasonable rates.
Excellent point.
Kevin and I got passionate on that, on that question.
That's okay. We're getting down to the end here. There is one question, and it goes to patent law, Kevin. A process that's passive, that's been patented, and once it goes public, how is there any way to detect whether someone has used a passive process that you've patented? It sounds a bit like a technical question. I'm not sure we can answer.
No, I got it.
But
I got this one. Yeah. No, that's an excellent question. And it goes to, shall I say it a third time? The value of a patent is your ability to enforce it. And how do you enforce something if you don't know it's infringed? Well, if you have a spy in the organization that could rat them out and say, yeah, you know, they're actually doing the process exactly as you've patented, that would be great, but that often doesn't happen. So the issue is, if there's infringement, how would you be able to detect it? If you think somebody is making a product with your patented process, but you're not sure, you have a dilemma. And especially when you inform your board about that, and your board is asking what, what is counsel recommending? What do we do about this? Do we file a lawsuit and go down the path and spend thousands and thousands of dollars undertaking discovery on the risk, taking the risk that maybe they don't infringe? Maybe they are making that product using a process that is slightly different than and outside the scope of the patented process that the company has obtained. So that's an excellent question. It's a consideration to think about at the very beginning when you're deciding whether or not to patent an invention. How would I be able to detect infringement should it occur?
Great. As we get to the end of our hour here, what are some of the key takeaways about IP that entrepreneurs should keep in mind? And that goes to both Kevin and Heather.
Ladies first.
I often sit through these kind of startup IP presentations and any corporate presentation, and I know we sound like you need legal with a big red flag, right? I want you to know I get it, right? This is not a situation of everything has to be done perfectly from the get-go, because you probably don't have enough money for that. But this is a situation where you should know everything you're doing. That would be my takeaway. The number one thing is keep track of everything you're doing, even if it's in a notebook, the first time you sold that coffee or the first time you sold those services, because at some point someone is going to ask you, now we're working backwards and we want to get up to date on things. When was the first time you sold that? Or what agreements have we entered into? What agreements have we not entered into? Where are we keeping our data? You want to keep track of as much as you can for yourself so that when it comes time to work with us, it makes our job easier, which makes the price go down. That would be my takeaway. And I would also say, get our opinion early. even if all you have time for is an hour consult, it's better to get our opinion on what we think is important so that at least that's taken care of, than waiting and trying to backtrack on things that you probably should have prioritized.
Super, thanks, Heather. Kevin?
So the takeaway I would provide is, and the whole reason I do these kinds of workshops and seminars is to help entrepreneurs understand what intellectual property is. So many times entrepreneurs don't even know the right questions to ask. They confuse trademarks with trade secrets, patents and copyrights. And I know that we've covered a lot of information here today, and it's probably like drinking from the fire hose for some of you, but it's really important to understand the basics. And when you are talking with an attorney about your intellectual property, whether it's us or anybody else, come prepared, understand sort of, ask the right questions, the questions that you need to find out in order to make a decision about how to move forward with intellectual property in your company. And then the second takeaway is integrate or understand how intellectual property works is part of your business planning process. How does it affect your business? What are your goals with that intellectual property? Are they offensive, defensive, or otherwise? Is it a licensing play that you have in mind? Think strategically about intellectual property as opposed to just sort of a check the box, I did that, now I can move on and forget about it.
Super. Well, thank you very much, Heather and Kevin. We appreciate the time you've spent with us today and the time preparing for today's workshop. I want to thank all of our participants for coming and asking great questions and being available. If anybody has any questions related to anything said today, you can reach out to me. My email is llonzi@stubbsalderton.com. And I will make sure that you get that. You should probably all have it anyway. And then finally, this session has been recorded and will be up on our YouTube channel in about 4 days. And if you want to go back and listen to anything that was stated or any of the questions, that will be available also. Again, thank you all. Have a great afternoon, and I look forward to our next session. Bye-bye.